Okay, today we're going to talk about antitrust, and I'm going to actually talk about it in terms of the progressive era. So I call these slides antitrust and the progressive era. And so the reason I do that is that any kind of legislation that we ever had, whether it's the 14th Amendment, which was eliminating racism to a certain extent, or providing for equal treatment to all Americans, or whether it's the First Amendment that provided for a foundation for open debate of things in this country. Whatever these amendments and these statutes, in this case we're going to be talking about statutes, were, they reflected the era in which they came up. So the Revolutionary era was very concerned that people be able to freely speak their mind, and therefore they had as the First Amendment, and a very important amendment obviously, the First Amendment, which is fundamental. Later, as we went through the Civil War, we became concerned with equality of treatment for the free slaves. Setting them free doesn't mean anything if they're under the thumb of the former planters due to black codes, which quickly became apparent. And so the North actually took steps to provide for Reconstruction, and for a while there it worked. But eventually the burden of it became too great, especially with the economy doing badly, and a lot of that had to do with the fact that cotton wasn't really such a good crop anymore. There was too much competition from other sources. Anyway, we're going to talk first. I'm going to start off talking about the purpose of antitrust, because I think any legislative scheme has to be looked at in terms of what its purpose is. What we want from the judges is for them to fulfill those purposes. Whatever it was that we wanted to have happen, we would like to have happen with the statutes. Regardless of what the text says, we want them to actually do that which makes sense. So anyway, at least that's what I was always taught to believe, and I think we have a long history of that, much longer than this textualism, which is oftentimes probably better used in terms of contracts, and maybe to a certain extent with statutes, but not so much with constitutions. So anyway, the purpose of antitrust. One big purpose was to foster market competition, which was thought to be desirable in and of itself, and that would keep. And that would, a second purpose would be to keep prices competitive, and fostering competition was thought to do that. To eliminate unfair competition, in other words, to eliminate certain unfair practices that were seen as competitive. So we see statutes that basically declare that certain kinds of agreements are anti-competitive. To reduce monopoly power, that is fighting the curse of bigness. So Justice Louis Brandeis, a major progressive force, was very big on the evils of the curse of bigness and corrupting the government and corrupting the competitive nature of our markets. And so he was very big on that. And so a lot of people were at that time. The fifth one is to reduce political power of large corporations and their oligopolistic powers. So we had in the late 19th century, certainly in the West, where there was much less businesses, oftentimes you would find that the states in the West were dominated by maybe some political, by some industrial corporation which dominated the government because of it being the largest corporation, and everybody was employed by it. So everything was done in order to foster its interests, and not so much maybe for the individual, which is certainly not what we really wanted in terms of our government. So reducing monopoly power, fighting the curse of bigness, and that was seen as not only merely a matter of keeping prices competitive, but also in some sense making the possibility of competing available. In other words, there are a lot of problems with monopolies, in that it's hard for other individuals that start a business, if they're facing a monopolistic power that's going to fight the entry of new firms into the market. And so a fifth kind of purpose was to reduce the power of large corporations and their oligopolistic power. I already said that. So anyway, now 6, I just added this one. Maintain the promise of the American dream. What is the American dream? Everybody wants to be a success. So do you want to start your own firm? Would you like to start your own restaurant? Would you like to have your own business? Would you like to be your own boss? Many people have the desire to be their own boss and start their own firm. And of course, if trade is dominated by large firms, you don't see that. And so we've seen over the years that the trend has been to eliminate competition. Small firms don't really exist, at least not in the way they used to. So a small restaurant owner might be a person who is a franchisor, so he's working under really a big corporation, say like McDonald's, but he's got his restaurant. But then again, it is possible for people to start their own restaurant, and some of those restaurants actually provide something a little different than what you can get from the big chains. And so this seems to be the kind of thing. And you know, at the time in the late 19th century, there was a lot of talk about the American dream, and you know, that it was losing out. And I think in the early part of our country, there was a lot of opportunities, you know, for people to have their own businesses and succeed on their own and create something on their own. So it was basically like people could just go out west and build up their own farm and maybe even start their own businesses. So Levi Jeans was created by a tailor who went to San Francisco and found that when he made jeans out of the canvases that were used for the sales, that these were very durable and very much in demand. And so this is how they came about, by the fact that this tailor had moved out west in order to start his own business. And because he didn't have other materials to make jeans with, he made them out of canvas, which turned out to be very durable and very much sought after by the miners, who were very much wearing these jeans because they were so durable, and was something that they needed when they were digging in the earth to get the gold that they sought. Anyway, there are certain anti-competitive behaviors that these statutes address. Monopolizing obviously being maybe the first one that people think of, but not the only kind of anti-competitive behavior. Monopolizing is, you know, it's not having a monopoly that is evil. It's actually driving people out of business in order to control the market and keep your prices high. That's what we want to discourage. That's the anti-competitive behavior we want to aim at. Sometimes there are natural monopolies, and in that case, there's no sense in trying to create more competition, because there's only room maybe for one firm. So let's say you have a small town and 10,000 people. How many newspapers can 10,000 people support? If 2 newspapers are operating, one of them will go out of business and it'll return to being a monopoly. And so that's what you would call a natural monopoly, because there isn't room enough. There's not enough customers for 2 newspapers in that town. So there's going to be one newspaper. And that newspaper isn't necessarily monopolizing. It's, you know, it's just the fact that only one newspaper will survive. But also we need to talk about other anti-competitive behaviors. And so we'll talk about predatory pricing, which is sometimes used in order to gain monopoly power. So predatory pricing might be to lower your price in order to drive out competitors, and then after you've driven out competitors, you impose a monopolistic price. What's a monopolistic price? Monopolistic price is a price that wouldn't be found except in a situation where the seller has no competition. So he can set a price. He's not going to set it at any price. He's going to set it to maximize his profits. but that's going to be a higher price than if he had competition, because he would have to maybe keep his prices in line with competition. So he could set a slightly higher price, maybe a substantially higher price, if he doesn't have competition. So predatory pricing, which is basically cutting your prices in order to drive out others from businesses. Now, some people claim, well, that never happens, but in fact, I think it did historically happen. And I think there are cases that can be looked to show that. Conspiring to illegally divide up the market. So, basically, these antitrust laws, some of them provide that competitors cannot conspire together to fix prices. So, basically, one way of doing it is to divide up the market. Okay, I'll operate in the southern part of the state, you operate in the northern side of the state, and we won't compete. And that way we can both have a higher price and make more money than if we compete. So we could agree to that. If we can agree to that, we could make more money, but it's not in the interest of consumers, is it? And it's not a competitive price. And so conspiring illegal to divide up the market. Unfair trade practices, there are a number of these things, like a manufacturer who dictates to the sellers what price they can sell his product. This is frequently done. So some of that may be actually fair, but some of it may be unfair. So unfair trade practices, and so those have to be looked to. So what are the negative regulatory issues that we face? So I've given you some, and the purposes, you can see there's some positive purposes to maintain competition and to create a situation where people can compete fairly. But what might be the negatives? So we talked about the positives, now let's talk about some of the negatives. Regulation, over-regulation can affect innovation, so it basically might discourage innovation. And in favor of you don't want to take a risk on something new when you might be put at a disadvantage. Some people would actually argue that it encourages innovation by having more competition. Anyway, so also another regulatory negative would be that the regulations, the antitrust regulations or other regulations of the government, might place American firms at a competitive disadvantage versus foreign firms. And so this could be, in some cases, a certain size may be necessary to maintain, to compete in a market that's an international market. And so if our government is restricting the size of businesses, that might put them at a competitive disadvantage, as opposed to, say, firms in France or Germany or Japan or somewhere else where they don't have to, where they will not be restricted in terms of how large they get, because how large you get means you can lower your prices, right? And so placing the American firms at a competitive disadvantage is something that should be concerned in regard to how they interpret and how we use these regulations, if we're going to have these regulations. Also, a third negative regulatory issue is the antitrust laws may lead to higher prices for consumers. So, consumers benefit by fair trade, open trade, by an international competition in prices. We basically will produce those things that we have a competitive advantage, and other countries will indeed produce things where they have a competitive advantage, and as a result, consumers will get not only lower prices but also maybe better products, because each firm will be pursuing, each country's industries will be pursuing those things in which they can do well, and so that might be a negative regulatory issue. Higher prices for consumers, maybe less innovation. Yeah, all that. Antitrust. So let's take a look at these antitrust statutes. So these are antitrust statutes. The first Antitrust Act was probably the ICC, the Interstate Commerce Commission, which arose because the farmers out in the Midwest along the railroad, North Dakota, South Dakota, Nebraska, Kansas, all along there, they only had one way to get their produce, their cattle, their farm goods, their wheat, had to go on the railroad. So the railroad was a bottleneck, and so the railroad basically would charge high prices because there was no competition. So there was one railroad that had been built by government money, and it wasn't regulated until the ICC stepped in and began to regulate prices. And also there were issues in regard to storage of say grain, and the prices that would be charged for firms that stored the grains were oftentimes very monopolistic prices, because they would build this big tower, and the prices, the distances were so far between these, where these things were located, that those prices could be driven up quite a bit. And so the ICC and certain state statutes regulated that, and so that became an issue as to what prices could be charged for these things. Obviously, the railroads and those people who had granaries where they kept grains needed to make a profit, but there was a wide-scale belief, and it was probably true, that the people with the granaries and the railroads were charging too much and basically creating a bad situation for the farmers. So you had a political movement, a populist movement, which was very much interested in establishing that. So you had the Interstate Commerce Commission dealing with that. So that was maybe the first act that got passed, first big regulation of market conditions. Sherman Act came a little bit later than that. In 1890, it was still in that Reconstruction era. In the 1890s, the Sherman Act was passed by Senator Sherman and others. Senator Sherman was the brother of General Sherman, and may well have been the reason that General Sherman was a general, right? Because politicians actually, would have influence with other politicians and maybe get their relatives appointed to positions. Well, anyway, General Sherman was certainly a good general, and Senator Sherman had his merits too. He passed this act which dealt with restraints of trade. These were unfair trade practices. So things that would, conspiring to fix prices. Fixing prices is a classic kind of restraint of trade. If you fix the prices on something, that means there's going to be maybe less supply of the prices, and the prices will be, you'll be fixing it at what? If you're the sellers, you're going to be fixing it at a higher price. So you get together with others and collude to set a higher price, which is not of the market price. Rather than competing, you're actually colluding on the prices. And of course, also the antitrust, the Sherman Act also dealt with monopolization. And the ideal there was to break up the large corporations, because they were largely seen as destructive to the American dream. That it would mean that competitors who wanted to enter into a market would be maybe driven out by these already existing corporations that had control. And so this was contrary to what they thought the American dream was. The ideal of the American dream was that new people coming along, young people going into business can actually maybe achieve something and create their own firm. But what if there is no possibility of that because of the fact that you're going to have somebody who's engaging in predatory pricing or some other mechanism by which to keep people from competing against them. So it dealt with monopolization. It wasn't the only act that dealt with that, but there were other acts that followed it. The Clayton Act of 1914 dealt with price discrimination and merger. So mergers is a way of monopolizing in a way. You merge with other firms and thereby eliminate competition. So, you know, you could either merge with the firms, or you could maybe acquire the firms, you know, and become a monopoly. Monopolization is the problem, though, and that can happen through mergers. You know, especially if you have a sector, a market which is not very well populated. That is, there aren't too many firms operating it, and therefore, you know, if suddenly firms are combining, then you're eliminating the competition. So that was what the Clayton Act was primarily designed to do, and oftentimes, and they had some sort of formula where they, and we'll talk about that, where they would look at the size of the market to see whether it was competitive or not, and therefore they would go to court and get usually an order, an injunction for a certain merger not to take place. Typically, oftentimes they sought to work with the companies that were maybe going to merge and get some sort of consent from them and get them to agree to not merge in order to maintain that. And you know, those firms had the prospect of maybe having a court order stopping them from merger, so oftentimes they would agree. The FTC Act, that's the Federal Trade Commission Act, 1914. This act came along in order to provide an administrative agency that would administer these laws. And so it would be a permanent kind of force, rather than leaving it up to, say, the Department of Justice, you know, and the federal lawyers who work for it. You would have an administrative agency that would deal with this, which would lower the cost and be a permanent fixture in creating competitive markets. So 1914, and also would deal with some issues like maintaining quality. So certainly, you know, the FTC also does things like the Food and Drug Administration, where they're making sure that people are you know, not consuming or buying harmful products. Okay, we've been talking about the Sherman Act, and the first, a lot of the first cases involved claims of price fixing, which was very much opposed by a lot of the populace at the time. So farmers who were subject to these high prices were basically sometimes complaining about price fixing, and in some cases it was either a monopoly, an actual monopoly. Other cases it was just a firm that had monopolistic power. So you don't have to be a monopoly to have the power to impose a monopolistic price, and that certainly is true if you're in an agreement with other firms not to compete. So anyway, price fixing is blatantly and substantially anti-competitive. It is therefore universally and always held to be an illegal restraint of trade. There cannot be an assertion that price fixing is ever a reasonable restraint of trade. So the ideal is that you would think, ideally, that the firms would be competing on market price. And so that's inconsistent with agreeing as to the price that you're going to sell your product for, or dividing up the market so that you're not really in competition. It's just not consistent with the ideal of a market that's competitive. There cannot be an assertion that price fixing is ever a reasonable restraint of trade then. Similarly, certain horizontal restraints, group boycotts, geographic market divisions, have been found to be per se violations. Per se means that if you prove that there was an agreement to fix prices, that's all you need to prove. You don't have to prove that the prices were, you know, not competitive. You said, well, they just had disagreement, and that would be enough. Same way with a group boycott, where, you know, certain firms were driven out by a boycott of their products. And so we'll talk about these as we go along. These are found to be per se violations. Geographic market divisions, and there are other kinds of divisions. Balancing tests. Other kinds of cases require the court to weigh the anti-competitive aspects against the pro-competitive aspects to determine whether the agreement is predominantly one or the other. So, for instance, it's perfectly sensible for a car manufacturer to have different kinds and to approach his market as being different segments. That is, there are different segments of a car market. So there are the family cars, and the firms compete to sell family cars. There are the luxury cars, and they compete to sell luxury cars. There's the sporting car, the sporty car that also is a part of the competition. And there are the economy cars. Okay, these are separate markets. Now, however, let's say a firm was to agree with another firm that it would be the firm that produced the family car, and so they wouldn't be competing in that market with each other. So that would be an illegal agreement, and basically would be fixing prices, and would be maybe a per se violation. Or they weren't. So one firm would be given the job of making family cars. Another automaker would be given the job of only making the economy cars. Okay, and then maybe there's one that just makes luxury cars, and they don't compete with one another in these cars. But what you see in our society is that most of our car dealerships, most of our car manufacturers produce all four of those kinds of cars. They produce luxury cars, they produce sporty cars, they produce family cars, and they produce economy cars. So, that's the ideal situation, that they're competing, rather than saying, well, I'm going to be the one who, will dominate and be the primary one to actually have this kind of control over the market. So we can all make more money that way, right? And so that's not what we want. And so other kinds of cases require the court to weigh the anti-competitive aspects against the pro-competitive aspects to determine whether the agreement is predominantly one or the other. If it is predominantly pro-competitive, then it is not an illegal restraint of trade. Okay, so certain agreements might be pro-competitive. This is also called the rule of reasons. So this was a famous kind of decision that arose out of Taft, actually. So anyway, some vertical restraints that might be engaged in, which could be restraints of trade. Vertical restraints would include territorial or customer restrictions. So like I said, you're going to sell to the people in the southern part of the state, and I'll sell to the people in the northern part of the state, and we'll divide up the market that way, and we'll both be able to have a non-competitive price, a monopolistic price that will allow us to make a lot more profit than if we were competing. A resale price maintenance agreement. So this would be where I basically require anybody who wants to buy my product to pay a certain price. So I'm not competing, and I'm not allowing retailers to maybe compete. So retailers, when they're buying my goods, they either understand because of communications we had, or maybe they even sign an agreement that they will not charge below a certain price. Now this is typically done these days, but it was at one time thought to be illegal, and so I think it's a very common kind of thing. If a manufacturer wants to, say, keep his image of producing a high quality product, he might not want his jeans being sold at a lower price. So you might be required to charge a certain amount of money for a Levi jean, and the same could be true of any product. And so, and you can see this, I think sometimes this is abused today, because when I'm buying computers, I'll notice they'll say that they're competitive, but when I have two computers that look to me to be the same computer, but there's some slight differences between them, and they'll say, well, it's a different computer. So basically what I'm seeing is, and they can't sell below a certain price because the suggested price is this, and they're not really competing, even though they talk about competing. And so I don't know. So maybe we needed to look at these things a little more closely sometimes. But I think largely nowadays we do not really pay much attention to these restraints of trade that we used to, with the ideal of looking to the negative aspects of these regulations. refusal to deal, so that would be a boycott. Let's say that you are, that there are these department stores, and they're largely pretty much got the market in this town. There are 3 department stores, and they all agree that they will not buy a certain competitor's who's opened up his own retail store. He's competing against them, and they're handling all the other products. They will, however, not buy his products and sell it, so they engage in a group boycott not to sell his product, and thereby try to drive him out of business. These are not necessarily per se violations, but they are determined and weighed under the rule reason approach. That is, are they more anti-competitive or are they pro-competitive? That's the rule reason approach. Monopolization. A firm does not have to be the sole seller in a market to have monopolistic power. Okay. Having a monopoly is not considered illegal. Like I said, sometimes the law actually doesn't say that. It says that monopolizing is illegal. Okay. So having a monopoly is not considered illegal. Engaging in conduct with intent of gaining monopolistic power is illegal. And so this is how these statutes were interpreted. Monopolistic power is the power to determine the price of the product and the other terms. So the Sherman Act was actually decided on and determined what a violation was determined by the judges, and let's take a look at the Sherman Act. Going back to an earlier slide, I think it's slide 6. Every contract and restraint of trade is hereby declared illegal. That is not interpreted, that's the Sherman Act, and that is not interpreted literally. It is not taken literally. Not all restraints of trade are illegal. Only anti-competitive contracts. So you're using then the rule reason. And this was, like I said, set out in an... Okay, so basically the Sherman Act provided very much, it said very bluntly, every contract and restraint of trade is hereby declared illegal. But Judge Taft and subsequent judges found that only per se violations were actually illegal, and per se violations were pretty much confined to price fixing. Other violations were oftentimes seen as being restraints that would be subject to the rule of reason. That is, a judge would have to decide whether or not the restraint of trade was more pro-competitive or more anti-competitive. And so the judges would make that decision based on that. Now, whether or not they should be doing that, that's another question. So that seems more like something that an administrative agency might do, which would have expertise in maybe competitive markets. But that's not the way it reads. It's for the judge to decide that. And we didn't even have an agency until 1914. So the first acts were largely ruled on by judges, and they were applying not textualism, but they were looking at the intent of the framers, and the intent was to promote competition. And so they were saying, well, we're not wanting to get rid of all restraints of trade. Some of them are pro-competitive, some are not. We'll only do the ones that are anti-competitive. So that's what I say. And it kind of provides a nice contrast. Does anybody want to go back in terms of antitrust? Does any businessman want to go back to some sort of textualist interpretation of that act? I don't think so. So we talked about monopolizations, and we said that the market, what we're interested in is monopolistic power. Having monopoly is not considered illegal. Some monopolies are just natural monopolies. Oftentimes it might be a natural monopoly if it is a technical thing. So telephones were thought to be a natural monopoly. For years and years and years, telephone was a monopoly. And then recently they had, just in my lifetime, they had changed it to where they would allow competition in. So was that an improvement or not? Now that's the question. Attempts to monopolize. If the defendant with adequate market share has attempted to monopolize the market during the attempt, he had a dangerous probability of success, then a violation was deemed to have occurred. And so they would look at market share. So the Clayton Act provided for 4 distinct forms of behavior that are made illegal, but only if the behavior tends to substantially lessen competition or tends to create a monopoly. These behaviors include price discrimination, where you're charging different prices to different sellers without some sort of justification for the difference in price. You can do it if there is a justification for it. Exclusionary practices, these are group boycotts. They may be anti-competitive. Interlocking directorates where executives are sitting on more than one firm. And so if all of the heavy electrical equipment industry, all the directors are sitting on the board, so everybody has the same directors, then you're not really going to have competition. So interlocking directorates, even if it's just a few, the few could tell the others what the other one's doing, and then they could all just kind of, you know, without even putting it into the minutes, agree to certain prices and certain restrictions on how they'll compete. Mergers. So mergers are a danger because it could result in one firm dominating the market. Even if it's not the only firm, it might still be dominating the market. Price discrimination. Any differences in price for substantially identical goods offered to different buyers must be justified by either cost savings for the seller, or, you know, that happens if you're going to buy a large quantity and sell a large quantity. And so, you know, that happens all the time, that there can be a justification for price discrimination. You're going to buy a lot of the goods from me, I'm going to give you a lower price because I have less transportation costs, you know. And so there has to be a justification for the cost savings for the seller, or it must be necessary to meet the price of seller's competition. So are you doing something because other firms are doing the same thing? So you're lowering your prices because other firms would be lowering their prices. The alleged discrimination must be shown to have had an anti-competitive impact. The goods must be in interstate commerce, of course, because that's required by the Constitution. Exclusionary practices. These tend to lessen competition or tend to create a monopoly. They can be declared illegal using a balancing test. Practices include exclusive dealing contracts, where, you know, you're only going to sell your goods to a certain person or through a certain outlet. This might be monopolistic. Tying arrangements, where, you know, if you want my really great phone that's really hot and people want to buy this phone, you've got to agree to sell my other phones. And so that would be a tying arrangement, to where you know, have to sell all my products and not just the ones that are really kind of hot and competitive. And so that's going to keep prices up. Interlocking directors, we talked about that. No person can be on the board of 2 or more competing corporations at the same time if either the corporation has capital surplus, retained earnings, or undivided profits aggregating over a certain amount, or competitive sales above a certain amount. The amounts were adjusted. On this one, the FTC basically made these determinations. The Federal Trade Commission, the agency, would basically be kind of looking at these interlocking directorates to see whether there's some violation in there. So would there ever be a case where interlocking directors might be beneficial to competition? There might be, so I think they need to look at it in terms of real reason. Type of mergers. There are various types of mergers. Horizontal mergers between firms in the same market. Those are more likely to be anti-competitive, especially if you eliminate all the competition. So if all the firms that are selling, say, bicycles all merge, then there's only one firm selling bicycles. It's a monopoly, isn't it? But don't necessarily need to have a monopoly to have monopolistic power if you dominate the market So 90% of the firms making bicycles are the same firm. And maybe there's a firm that only produces high quality ones. It's not really competing with the others. It's only competing maybe in a narrow part of the market. So there might be monopolistic power there. Conglomerate firms, so vertical firms are firms where the firms in the chain or distribution to the ultimate consumer. These are generally not going to be vertical mergers are not generally going to be thought of as being anti-competitive. I mean, theoretically they could be, but they're generally not. It's a way of lowering prices, and actually maybe is more pro-competitive than anti-competitive in most cases. Conglomerates, firm without significant or substantial connection in marketing or products or services. Those tend to be, again, not anti-competitive, not monopolistic. Horizontal mergers, the merger's significant impacts upon market concentration it's prohibited. Factors to consider: overall concentration of the relevant market. So the agency, the FTC, would look at how many firms are out there to compete, and if in fact there's only like 2 or 3 firms, it might basically prohibit further mergers because you're not going to have much competition. So you have that situation with certainly we see that in terms of accounting firms, but there are 4 really big, large accounting firms that compete, and so that means the market is less competitive. And so I don't think they've ever ruled that was that. It's a different kind of situation because what you're dealing with there is oftentimes a quality issue and not so much a price issue. So facts to consider: overall concentration of relevant market, whether this market's historical tendency is toward concentration. So is there some sort of justification for there being concentration? Is it becoming more concentrated because of technological innovations that require it to become more so, or because maybe they're competing with foreign firms? Is there an intent to increase the firm's market power or to restrict competition? Does it appear that they're doing this in order to gain market power illegally, basically? Horizontal, so we talked about vertical mergers. Vertical mergers are less likely to be considered a violation, as I said before. However, if the effect is to foreclose competition in the markets of either firm, then it can be a violation. So, in fact, you have to look at the horizontal situation where you have a vertical merger. So you're buying a supplier. Are there other suppliers that can supply other people, or are you tying up a primary supplier that's going to be supplying most of that, and therefore having an impact on your own competitors because they can't have products that compete with your products because of what you're doing. So the factors to consider: market concentration in both the vertical, the buyer of the firm and the seller of the firm. So these firms that are merging, you have to look at each of their horizontal markets. Barriers to entry. So are there barriers to entry? This is a classic way to restrict competition. Apparent intent of the merging parties. Like I said, you need to look at the pro-competitive and anti-competitive aspects of this. And so we're getting down here to the end here. So we've been talking about this. So these are the legal tools. Consent orders. Consent orders are basically the FTC maybe looks at a market and says, oh, well, it looks to me like it's getting anti-competitive. And it then contacts the executives of those firms and talks to them about their situation and gets them to agree to certain business decisions so as to maintain competition. And so, and of course they do it, and the reason firms will do it is because of the threat that the agency, the FTC, would maybe seek an injunction, or in some cases they might go to court to seek an injunction, which is an order from the court for the firms not to merge or to stop doing whatever the anti-competitive behavior is that you're doing. And the other thing is that they could also as a legal tool, so injunctions are a legal tool, and also divestments, or breaking up the firm. So one of the big cases on that, one of the big cases was Standard Oil, which was broken up into the Seven Sisters. So Standard Oil was one huge firm which was controlling petroleum, gasoline, and at the time automobiles were becoming an important part of the market and a very huge part of the economy. And so there was a lot of things. And the ideal was that many people wanted to buy these cars. And if the gasoline cost a lot of money, it was going to maybe impact the market. And so they broke up the firm. And so that was done largely pursuing a progressive ideal of making products more readily available to people. So so-called American dream, so everybody can have a piece of the pie, right? Everybody gets to have a piece of the pie. Everybody can compete. You can start your own business maybe. And so that's it. Fines are another thing that they can use as a legal tool. And so basically that's it for this segment. Like I said, anti-competitive behaviors that we talked about, monopolizing, predatory prices. These are kind of primary anti-competitive aspect. Predatory prices, like I said, is always going to be illegal. Monopolizing is not necessarily illegal. Conspiring to illegally divide up the market, that's vertical or horizontal mergers, oftentimes will be dividing up the market. You can also do it in terms of product, dividing up the products that you made, as we talked about. Unfair trade practices are things like requiring people to sell your product at a certain price, dictating to the retailers what prices they will sell, or requiring them to actually buy, they can only buy a desirable product if they agree to buy other products from you also. And so that would be an unfair trade practice, which might be found to be anti-competitive. Negative regulatory issues we talked about were the effect of innovation. So these restrictions might have a negative impact on innovation. I think this was much discussed in terms of the internet and the browsers. Microsoft came out with its own product. It was late in getting so before Microsoft came out, there was a browser that was very effective, and that was pretty much driven out of business by Microsoft because Microsoft was giving it away. And what Microsoft had done was found to be illegal by the European Trading Commission. So the Europeans have their own antitrust laws, and they're much more strict than we are. And especially I think maybe there's a charge that maybe they were being more restrict because Microsoft was an American firm. So, they were accused of being unfair in that. But we did have that situation where the court did declare it to be illegal, and then it was found not to be illegal, so it was kind of like a back and forth on that kind of thing. Effect on innovation becomes an important thing. Place of American firms at, do these things place American firms at competitive disadvantage versus foreign firms? Well, yes, if foreign firms don't have these same kinds of restrictions, it might be that they might gain some advantage, although I don't believe I've actually seen that happen. Matter of fact, like I said, the European Union and a lot of countries have much more restraints on the trades of these products. So basically, you take the social democracies of Europe, they generally have more restraints of trade than America. So I don't know that that's really a factor in regard to our products. Result, maybe we're the ones who are getting the advantage by not having a very strict enforcement and using a rule of reason to determine whether it's enforced, rather than using a textual, literal approach. Also the fact that, in fact, some of these restraints in trade may result in higher prices for consumers. Yes. So, I mean, that's what we talked about, and that's it for tonight. Thank you.